Good morning, students. We are on week 4 of online learning. And today we are going to try to complete the topic of patents and trade secrets. And the most important thing that we have to remember when we are looking at intellectual property rights are that these are intangible assets, and these assets are things that actually make the company um, um, basically have value, right? Because assets basically have value. And as companies increase their intellectual property rights, the value of the company also increases accordingly, right? So as you know, right, you have got two types of assets. One are tangible and the other is intangible. So intellectual property rights fall under the category of intangible rights. Now, if you look at copyrights, which we have already completed, copyrights basically are intellectual property which exists in the context of expression of ideas. All right. Now, on the other hand, patents basically uh, talk about, or patents basically protect the inventions that a person have actually created. Okay, so they're basically different. One is protecting the expression of ideas, the other actually protects inventions. Okay, now, so what is the criteria to protect inventions under the patent law, right? So there are three criteria. Okay, one is it has to be new or novel, right? Second is it has to be something that has an inventive step, all right, which is not obvious to those who are in that area. So you talk about non-obvious, right? And then finally, it has got industrial use, right? Now in the United States, they talk about it is useful, right? But in Malaysia, the law follows the United Kingdom law, and it uses the concept of industrial use, right? So these are the three criteria, and basically patents can actually protect products or industrial processes, right? So not necessarily just products. It can also be, in relation to industrial processes. Okay, so these are the categories under patent law. Now, there is another category of invention. They call it utility innovation. All right, that is also available in most countries under the patent law. Whereas patent law protects inventions and gives you a monopoly right for 20 years, utility innovation is something of, you can say, a lesser degree of protection and less stringent when you apply for it. So when you actually put in an application for inventions, right, you have to go through those three steps. It's novel, right? It involves a non-obvious step, and then finally it has got industrial application, right? However, for utility innovation, you do not actually have to show that it involves an inventive step. You just have to show that it's something new and that is industrial use for that particular utility innovation. Okay, now, and also in terms of the period of protection, it is 10 years. Now, sometimes when you're not very sure that you are going to get the patent grant, and when you put in an application, if you're not sure, you can actually start application for your invention as a utility innovation. Midway, you can convert it into a patent application, right? And vice versa. Or you can start off as a patent application, and midway, if you feel that you're not very confident, you can actually convert it into a utility innovation application, right? So basically, both deal with invention, but for patents, the requirements are more stringent, more strict than and more difficult to obtain in comparison to utility innovation. All right, now, so basically, if you look at why is it that the state actually uh, gives this grant to the uh, person who is applying for patent if he's successful. This is so that more and more people are encouraged to, come up with inventions which will be mutually beneficial for the person who is going to obtain the patent as well as the country in which the patent is applied, right? Because at the end of the day, all this innovation is going to stimulate the economy of a country. So therefore, the state, in exchange for the information about the invention, the state will give a grant, and in that grant, the owner of the patent is given a monopoly right for 20 years. Now, during that 20 years, the owner has got exclusive rights to exploit the patent invention, also to assign or transmit the patent to others, because if he wants to actually commercialize, for example, the product, then he may want to actually assign the rights in that patent to third parties, and normally they do this through contracts. Or alternatively, they can give a license to certain commercial concerns to actually do certain things with that patent for a limited period of time, right? So therefore, they enter into licensing contracts or licensing agreements. Okay, so this is where we looked at last week, right? And finally, we looked at infringement. And infringement means that whenever someone else, infringe the rights of the patent owner. In other words, do anything that the patent owner has the right to do under the patent without his permission, then the patent owner then has the right to institute court proceedings, and basically he has to bring these court proceedings from within the period of 5 years of the infringement. Otherwise, he loses his right to to bring the court action. So basically, that's where we looked at, and then we also looked at the law in Malaysia, which is the Patents Act 1983. Now, this is the Patents Act 1983, all right? As you can see, it has got the different parts of the sections, and you can see here, they tell you what is patentability, all right? What are patentable inventions under Section 11? What are non-patentable inventions, which we are already looked at in the last class? What are utility innovations? And what are the rights to a patent that an owner has, and all the applications procedures for the grant. See, all of these things are in the what do you call it, the Patents Act 1983. Okay, now what I would like to do now is to actually begin the topic today, right? And I would like you all to also look at some of the videos. I will play one video right now, which will show you how the patent classification system works.
Do you have an invention that you would like to protect with a patent?
Sorry about that.
Do you have an invention that you would like to protect with a patent? A patent is a mutually beneficial exchange between an inventor and the public. For an inventor, a patent offers protection by excluding others from making, using, or selling the invention. In exchange, the idea is made available to the public through the publication of the patent. This encourages even more new innovations. In order to get a patent approved, your invention must be new, useful, and non-obvious. In other words, you have to make sure your idea has not already been thought of by someone else in the US or the world. The most effective way to see if your idea is original is to search for patents by classification in the global patent database called a SPASnet. When you walk through a movie store or browse for a movie online, you are using a classification system. Movies are commonly organized by classes called genres, such as comedy or drama. Genres make it easier for you to find the type of movie you want to watch. Patents are also grouped together into classes and subclasses so that you can find inventions similar to your own faster and easier. The IPC is an international classification system developed by the World Intellectual Property Organization and used by over 90 countries to simplify patent organization. Instead of searching each country's patent classifications individually, the IPC allows you to search all 90 countries' patents at once. The United States Patent and Trademark Office, or USPTO, has its own patent classification system called the USPC. They began transitioning to the cooperative patent classification for utility patents in 2013 and will finish in 2015. The Cooperative Patent Classification, or CPC, is a collaborative effort between the US and European patent offices. It is an extension of the IPC that has almost 200,000 more subclasses. These subclasses allow you to be more specific when searching, which means you have less patents to look through. Because of the way patents are classified, keywords alone are not an effective search strategy. Let's say your invention is a new and improved waffle maker. A search using the keywords waffle maker only brings up 50 results. Yet there are hundreds more patents describing equipment used to make waffles. This is because people in other states or countries might call a waffle maker something different, such as waffle iron, or use more technical terms than the average consumer. If you search with only the term waffle, about 3,000 results are found, including many irrelevant inventions, such as this cooling garment that uses the term waffle to describe its shape. If you search by classification, you are less likely to miss patents similar to your idea, and you will have less irrelevant patents to look through. When you begin your search, be sure to write down all the terms that best describe your idea. What does it do? What is the end product or effect? What is it made of? What is it used for? Remember to write down everything. Once you write everything down that describes your patent idea, you are ready to find relevant classes and subclasses. We will use the SPASnet database, which has both US and international patents in the same place. To get to the classification search, go to worldwide.spasnet.com, then click on Classification Search. To search with keywords, type the terms into the box and click Search, then choose from the results. To browse the classification, click on the symbols to get more and more specific classes. The hierarchy of classes and subclasses is visually shown with dots. The box with a D on the right-hand side indicates a definition or suggestions for another class. Notice here that domestic waffle irons are in a different class. I will write both subclasses down to search later. Remember to think of how an invention works, not just how it is used. For example, if you create a new hinge for the waffle maker, you would want to look for hinge patents as well as waffle maker patents. What other inventions might use a hinge? If someone has already thought of the same hinge, only for a panini press rather than a waffle maker, your idea is not original and therefore not patentable. Now that you have relevant classes and subclasses, it is time to start reviewing patents. To get to a list of patents in a particular subclass, you can check the box next to the class and click Find Patents. Type the class into the Smart Search and click Search. Or put the classification into the advanced search screen. Make sure there are no spaces in the classification. Once you have a list of patents, click on the titles to review each one individually. A summary of the patent appears on the screen. If a patent is in another language, you can use the red Patent Translate button to translate the information into the language of your choice. The menu on the left side allows you to navigate the information in the patent. To download a patent, go to the Original Document tab and choose Download. You can collect up to 100 relevant patents in My Patents list by clicking on the red star. To view your list, click on My Patents list at the top. You can download the collection as a PDF by checking Select All, then clicking on Download. The PDF will include a cover sheet with a table of contents to your selected patents and an outline to navigate the patents. Patents are often assigned more than one class. You can use your relevant patents to come up with additional subclasses you didn't think of the first time around. Not all patents have been assigned a CPC number, so it is a good idea to write down both the CPC and IPC numbers and search for them separately. When you click on the class, the description will pop up, allowing you to decide if the new class is relevant to your idea. Showing that your idea has not already been thought of by someone else takes a commitment of time. Patent searches can take anywhere from 10 to 30 hours to complete. Use your new list of classes and subclasses to repeat the search process. A thorough patent search will keep going until no new relevant patents appear. To save time, keep a list of the classes and patent numbers you have already reviewed and copies of the relevant patents. This way, you know that you are not searching the same things twice. If you need further assistance in the patent search process or have questions, please contact the UCF Patent Librarian or visit the Patent LibGuide at guides.ucf.edu/patents.
Okay, so you can see why this is actually quite important for you to do a patent classification search, and for you to understand how to go about doing a search. Because once you learn how to actually search for patents in this patent classification system, you can make sure that your companies, before you actually embark on, applying for patents, you can actually make sure no other companies or no other people have actually patented the product that you are planning to patent. So that also protects you from, people suing you for patent infringement. So for many reasons, it's very important for you to know how to search for patents. And as you know, the video has shown, there's a classification system. You've got classes and subclasses, and then basically when you search for a particular patent, you not only put in key terms that shows not only how it works, and but also how it is used, all right, how it is used and how it works. Okay, so in that way you cover everything. Okay, so that is in terms of the patent classification system, right? So you have to understand which your product falls into which category, okay, of class. Right now, we're going to look at patent protection in the United States. As you have seen, in Malaysia, patent protection is given to those who file first, but in US, it is those who invent first. Okay. Now, if you look at patent protection in the United States, of course, it is provided constitutional protection under the US Constitution, specifically Article 1, Section 8, Clause 8, as well as Patents Act 1952. So, can you see the Act goes as far back as 1952? So, they've been, in the intellectual property field for a very long time, right? And they're definitely, even today, United States is one of the countries that top inventions around the world. Now, in the United States, there are three types of patent. In Malaysia, there are two, right? One is the patents, and the other is utility innovations. Okay, but in the United States, you've got three types of patents, which are utility patents, design patents, and plant patents. Okay, and the requirements are the same. It has to be novel. Okay, number one, this is the same as in Malaysia. Number two, it must be useful. This is similar to it has got industrial use or industrial application. And number three, must not be obvious. Or in the context of Malaysia, you say non-obvious or involves an inventive step. So the three criteria are the same to obtain for patent protection, right? Now, I will play you the next video, okay? That will also give you a good idea on, the introduction and the basics of the IP.
The foundations of patent protection. What is a patent? A patent is an intellectual property right granted by the government of a nation to an inventor that gives him or her the exclusive right to an invention for up to 20 years in exchange for disclosing the details of the new technology for society's benefit. In the United States, a patent is a legal instrument in the form of a document issued by the U.S. Patent and Trademark Office, or USPTO. This legal instrument gives the inventor of any new, useful, and non-obvious machine, process, manufacture, or composition of matter the right to exclude others from making, using, offering for sale, or selling the invention throughout the U.S. or importing the invention into the United States. A patent is granted for a limited time in exchange for public disclosure of the invention, and a U.S. patent is only recognized domestically and cannot be enforced in another country. The legal foundation for U.S. intellectual property rights was actually laid by the founders in 1787 in the very first article of the U.S. Constitution, which outlined the precepts of our democratic society. In Article 1, Section 8, Clause 8 of the Constitution, Congress was given the authority to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So, what is the rationale for issuing a patent? Every society that affirms intellectual property rights offers two basic justifications for doing so. First, the bargain or contract theory, and second, the natural rights theory. The bargain theory starts with the common sense premise that people will be encouraged to invent new products and services that benefit society if they are likely to profit by doing so. The U.S. Constitution thus offers inventors a bargain. If you invent something useful, then the Constitution and statutes say that as a quid pro quo, you can have the exclusive right to that invention for a limited time, after which it goes into the public domain and belongs to society. Many patents were issued as a result of this bargain, like the invention of the cotton gin in 1794, which boosted agricultural production 100-fold, or like the invention of the semiconductor in 1957, which created a trillion-dollar new industry and millions of jobs. There is something so simple yet economically potent about this concept. As Abraham Lincoln, America's only presidential patentee, noted, the beauty of the patent system is that it added the fuel of interest to the fire of genius. The second common justification, the natural rights theory, invokes another common sense premise that most of us instinctively hold to be true, that the product of mental labor is by all rights the property of its creator, no less than the product of physical labor is the property of its creator. As Daniel Webster put it, a patent does not give an inventor a right to his invention or an author a right to his composition. Rather, it recognizes an original, pre-existing, inherent right of property in such invention or composition. This right is not absolute, of course, and inventors' inherent rights may at times be restricted by national security or other concerns. Then, for disclosing to the public the details of this invention, to which the inventor has this inherent right, for society's benefit, the government will enforce the inventor's exclusive property right to that invention for a limited time. Two important public policy goals are thus served. First, the inherent property rights of inventors and authors to their creations are protected, thereby helping to ensure that the well springs of creation and productivity do not dry up for lack of incentive. And second, the benefits derived from these inventions and creations are ultimately harnessed to the public good through disclosure, thus promoting the progress of the nation and the general welfare of its citizens. So, can patent rights stimulate invention and sharing? To help understand how patent rights can stimulate invention and promote technological knowledge sharing, economic historians Naomi Lamoureux and the late Kenneth Sokoloff offered the following thought experiment. Imagine a world in which there was no patent system to guarantee inventors property rights to their discoveries. In such a world, inventors would have every incentive to be secretive and to guard jealously their discoveries from competitors, because those discoveries could, of course, be copied with impunity. By contrast, in a world where property rights in invention were protected, the situation would be very different. Inventors would now feel free to promote their discoveries as widely as possible so as to maximize returns, either from commercializing their ideas themselves or from licensing rights to the idea to others. The protections offered by the patent system would thus be an important stimulus to the exchange of technological information in and of themselves. Moreover, the cross-fertilization that resulted from these information flows would be a potent stimulus to technological change. And sure enough, extensive research in the US and other nations shows that patents do in fact serve a powerful stimulant to technological change and knowledge sharing.
Okay, so you can see the basis of why intellectual property protection is given in the form of patents. And it is extremely important to know the theories behind it. And of course, in this slide, you see the bargain theory and the natural rights theory, right? In bargain theory, basically, it talks about, the patent owner or the inventor striking a bargain with the state, to actually, get a monopoly right for 20 years. And this is the basis of the bargain theory. And in exchange, what is the bargain? Basically, the person who is applying for the patent is going to disclose all the relevant information on how to actually create that invention, right? So that's the basis of the bargain theory. The natural rights theory basically says that, if you come up with an invention, basically intrinsic in that invention, because you have actually, put in the effort to actually come up with the invention, intrinsic in that invention is the fact that you have some form of claim or, right over that invention. All right. Now, however, as you can see, definitely, when you talk about patents and patent protection, it is definitely going to benefit society, because after the 20 years it is going to go into the public domain, and the public can actually freely use the invention in whichever way they want to. It also promotes some form of interest among potential inventors to keep on creating, because they are going to get some form of benefit by creating, and that benefit overflows into society as well. However, putting aside technological advancement that these patents can actually bring into a society, there's also something wrong with patents, right? What are they? What is wrong with patents? I will play this video so you get an overview of what is wrong with patents, right?
This video is sponsored by Dashlane. Conveniently store your passwords and get 10% off with the link in the description. In 1997, a guy named Jeffrey Bezos filed U.S. Patent 5960411A, a method for ordering items over the internet. Here's what it is. Instead of adding an item to your shopping cart and then clicking buy, you'd just click buy. That's the whole patent. It's so comically vague because that's what makes intellectual property so powerful. The wider the description, the easier it is to enforce. Just listen to this one. An apparatus for use as a toy by an animal, for example, a dog, to either fetch, carry, or chew, includes a main section with at least one protrusion extending therefrom that resembles a branch. That, my friend, is a stick. Both of these are ridiculously broad, but unfortunately, that's not uncommon. What is unique about Amazon's one-click patent is that they actually use it. Usually, these are filed by non-practicing entities, companies that own intellectual property but don't do anything with it. Instead, they make money by suing anyone and everyone. These two graphs tell the story. First, this is the amount of patent-related litigation from normal practicing companies. Year after year, the number stays pretty much the same. And here are the trolls. Not only are they way more common, but they've rapidly increased in just a few years' time. And second, roughly 87% of troll lawsuits settle before trial. In other words, patent trolls are very common and very good at what they do. Their strategy is fairly simple. File or buy as many and as broad of patents as possible, and then find people to sue. Both they and the other company know the cost of going to trial, hundreds of thousands or usually millions of dollars. So, unless both parties are really confident, they make a deal. The company pays the troll just to leave them alone, who, by the way, now has even more resources to threaten even more lawsuits. You don't need much intellectual property to see how this is a broken system. But the problem is actually much worse than that. Okay, so you've got the next big idea, a zero-click mind-reading buy now button. Here's what you need to know about patents. To get one, your invention must be novel, useful, and non-obvious. You know, like a buy now button which buys now. Totally not obvious. Anyway, it also can't be a law of nature, an abstract idea, or a nuclear bomb. Sorry, I don't write the rules. They usually last 20 years, and unlike copyright, patents are not automatic. In the United States, you must apply to the Patent and Trademark Office. And so long as your application has a left margin of 2.5 centimeters and its capital letters are at least 0.3175 centimeters high, it'll be reviewed by an examiner, with all the speed of the DMV. The process takes about 2 years, but the office does provide patent-themed Halloween and Valentine's Day entertainment while you're waiting. Seriously. Once your patent is granted, it prevents anyone else from making the same thing without a license. In other words, it's a 2-decade government-protected monopoly. So why do they exist? The answer you've probably heard is pharmaceuticals. Researching and developing a new drug is, well, gosh darn expensive. Some say $648 million, others $2.7 billion. Whatever the number, it's a lot. Without patents, they say, no company would spend so much when they could just wait for someone else to, and then steal their idea. Someone could jump in and take all the profit from the person actually doing the work. Sound familiar, maybe? So patents are an incentive. And not just to make things you and I want, but also to explain how they work. Because sharing knowledge is kind of the basis for civilization. This way, when it expires, others can make it at a lower cost. Or that's the theory. The issue is, patents aren't always good explanations. In fact, that's by design. Because remember, companies keep them as vague as possible. Technically, patents should be so specific that a person with ordinary skill in the art could reproduce it, but technically they should also be non-obvious. So, yeah. The other issue is that patents aren't the only option. Google's search algorithm, WD-40, and Coca-Cola all famously chose to just keep their mouths shut. Trade secrets do run the risk of being discovered, but they don't expire in 20 years, and they're still legally protected. So a smart company asks itself, can we keep this secret for 20 years? If not, it should get a patent, but otherwise, it'd be better off staying quiet. Because of this, patents may not disclose anything that wouldn't already be discovered. What isn't really in question is that they can be a good incentive. Of course, companies are more likely to create something if it grants them a monopoly. The question is whether it's worth it, because during that monopoly, we all pay a price, the higher cost they can charge with no competition. When your phone costs $100 more, this is annoying. When the World Health Organization estimates 10 million lives could have been saved with existing medicines and vaccines, it's downright awful. And then there's the problem of waste. Patents, like any economic system, are a game. And when you add 7 billion players, there are going to be some unintended consequences. The obvious one are the trolls. Their defense is that those who invent something may not be the best people to sell it. Universities, for example, lots of research, but marketing, not so much. So they say non practicing entities buy these inventions from, say, a school and sell them to those who can use it. But ask those buyers, and they shake their heads. In this survey, 92% of respondents said they added new products or features from the license 0 to 10% of the time, and they rarely, if ever, prompted the development of any new products. In other words, companies had already invented something and bought the license only to not get sued. Microsoft, for example, takes or took money from HTC, Samsung, and Apple for patents like scheduling meetings on smartphones. Its phone was, to put it politely, a failure, but it still collects profit, and on a feature that nobody hardly uses. You might be thinking, so what? Who cares that the world's richest companies are losing some money? But all these billions of dollars spent on lawsuits is money not spent developing new products or hiring employees. When Google bought Motorola largely for its patents, it spent $12.5 billion instead of who knows what. This is what I call patent theater. In the same way that so much of airport security is just acting out the motions for little or no benefit, big companies often file and buy patents not because they actually need them, but because that's the game they need to play. It's not about innovation, it's about not getting sued. Chances are any one phone company will violate another's patent, but file enough of its own and it can threaten a countersuit. It's mutually assured destruction. It might be better if no one had them, but someone does, so everyone has to. While researching this video, I came across this article titled The World's 50 Most Innovative Companies. It's just a list of who has the most patents. Of course, number of patents doesn't really measure innovation. It measures the, well, number of patents. That probably sounds obvious, but it shouldn't be. Their purpose is precisely to increase innovation. This should be an accurate list. It's not because of all the unnecessary waste. Worse, there isn't really anyone to blame. Examiners have to review 500,000 applications a year, and under pretty stressful circumstances. Mistakes will be made, and companies have to file patents or risk being targeted. There is a solution to all of this, but that's the topic of the next video. And just as patents protect companies from theft, today's sponsor, Dashlane, protects you from the theft of your online accounts.
Okay, so we have seen there's like something wrong with the system in which you will see that more and more companies are buying up patents just so that they can protect themselves. And you have this companies called trolls, which really don't spend any money on research and development, but instead keep buying up as much of the patents as possible. All right. And of course, all of these things are going to cost society because every time that, they buy up inventions from, these smaller companies that actually put in a lot of effort to create inventions, these big companies come along, buy up these patents, and then they benefit from it without really having invested much in it. So basically, the system has gone wrong. Originally, it was there to encourage innovation, but now it is just like everybody is doing it because it is the thing to do. All right. So I will hope that you sort of got an idea on what is gone wrong with the patent system. And of course, what has gone wrong, basically, if you look at it in the United States, you'll find that it's very easy to file a patent. all right, in the sense that every company will try to actually file some form of patents or other. And normally when they describe their invention, they will describe it as broad as possible. So in the event they get a patent, it's easy to sue other people for infringement, right? However, if you compare it to the European Patent Office, it's relatively more difficult to get a patent, right? So again, you have got different considerations from the European Patent Office and then the United States Trademark and Patent Office, right? So that's basically what's wrong with the patents, right? Now you can see now you have got a rough idea on patents. Now you look at what are the hot button issues in cyberspace. So originally, we're looking at patents in general. Now we are going to look at internet patents. All right. And basically, internet patents are actually business method patents, right? Because when you look at patents and you superimpose it in the context of cyberspace, you'll find that it's more of more in relation to methods of doing business, right? And more and more, you find that the U.S. Patent and Trademark Office is finding that there are a lot of patent applications related to this, all right, which is the business method patents. So, what are business method patents? Okay, they are any processes involving data processing, calculations, and conversions. Now, just now in the video you saw, right? You've got the Amazon, click, one click, kind of thing for paying, right? So that's an example of a business method patent, right? And basically, these are used for business operations and management. Now, considering the fact that there's a lot of e-businesses today and they are growing in leaps and bounds, obviously, when they are going to operate from cyberspace, it is something unique. And how to actually run a business from cyberspace. So this is what method patents help these e-businesses to do. They come up with a method of actually, doing business in cyberspace, and perhaps they've got a kind of a process that facilitates e-businesses to do business in cyberspace. Okay, now I will stop here, right? And we will continue on Thursday. Okay, now remember I told all of you in the last class that I'll be considering doing an online live session. However, I would still like to uh, sort of discuss it in our WhatsApp group and to see some form of ideas that everybody has. Do they want to actually have the online session, or do they prefer a recording session on Thursday? So we'll have a discussion in the WhatsApp. So I thought that it'd be good to also get your input about it. All right. So, okay, I'll stop here for today. I hope you can actually relook at the videos so that you get a good understanding on this topic, right? Okay, thank you very much. Stay safe, everyone.